Today we're going to talk about the difference between a joint and a separate revocable living trusts. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which serves the Twin Cities as well as the greater Minnesota alike. Just a reminder, we're going to be talking about Minnesota law here, but a lot of what we talk about will be applicable to other states as well. And a reminder, if you like today's video, please feel free to like and subscribe below. It sure helps support the channel. So a big question that I run into quite a bit when I'm doing revocable living trusts for married couples is whether they should have a joint revocable living trust or separate revocable living trusts. Now, there are some very strong opinions in the estate planning community. Some attorneys are of the mindset that you always do separate revocable living trusts. Others look at more of the circumstances of the individual to find out what is more appropriate. I think I fall into the latter half of that group, having done a fair share of both types. But with that in mind, let's look at some of the pros and cons of a separate trust versus a joint trust. So what am I really talking about when I talk about separate versus joint trust? Well, you've got a married couple and they've got two options. This is the married couple, spouse A and spouse B. They're married. They can either do a joint trust where all the assets are shared, or they can do separate trusts. Now, in a situation where there's a joint trust, what happens when the first spouse dies is that all the assets are controlled by the second spouse in a continuing revocable living trust. And when that individual dies, the joint trust will distribute out as is set in the joint trust at the time of the second spouse's death. With separate trusts, when you have the first person dies, the second person or second spouse gets an income from the first spouse or from the first trust. This trust becomes irrevocable, and it maintains the principal in the trust. So the trust is irrevocable, maintains the principal, and the second spouse, surviving spouse, gets an income off of the trust. Now, when the second spouse dies, each trust in this case will distribute as they see fit to whatever beneficiaries they want. So that's kind of the difference between a joint and a separate revocable living trusts. So which one is better? Depends on the circumstances. Let's take separate trusts first, and then we'll talk about joint trusts after that. So the first benefit of having separate trusts is asset protection, or creditor protection, excuse me. When the first spouse dies, this trust here becomes irrevocable. And the second spouse is, of course, getting an income off of that trust. Now, because it's irrevocable, creditors of the second spouse cannot access the funds that are in the irrevocable trust. If it was a revocable trust, they certainly could access those funds. In fact, they can access anything in B's revocable living trust. But because A is irrevocable, it's inaccessible. Another benefit that you'll have with separate trusts is that you can have each spouse be the co-trustee of the other revocable living trust. That way, if, let's say, instead of dying, A goes into a coma or develops dementia, then B has access to all of the finances of A and can take care of anything that needs to be done, payments, managing investments, taking care of real estate, etc. Another benefit, and this is kind of the big one that a lot of people think of, is for remarriages or instances where there are children from either a previous marriage or previous life for each of the spouses, or for at least one of the spouses. So let's look at this situation here. A has a child, B has a child as well. So with a joint trust, let's say this is a joint trust. A dies, and B has access to everything in the revocable living trust. Now, when B dies, everything is distributed as B leaves it when the joint trust is when B dies. So if the joint trust when B dies says these children 1 and 2 each get equal amounts, then they'll each get equal amounts. But let's say B really doesn't like 1. They just don't get along. B's never liked 1. One was an adult when A and B got married. It's just a bad situation. After A dies, B can change the terms of the joint trust to disinherit number one and give everything to the second child. Now, with separate trusts, again, you can't do this, and you can actually avoid this problem. So you got A and B. They each have their separate trusts. After A dies, B gets an income. The principal stays over here. And we got to draw the children in here. So while B is alive, B is getting an income. The principal remains protected in the irrevocable trust. What happens when B dies is that the assets of B's trust are distributed however B wants. Let's say it's all going to number two, and the remaining assets in the A trust are going down to whoever they designate. B cannot change the terms of the irrevocable trust. It's irrevocable. They don't have access to doing that. They can change their own trust as much as they want, but not this trust. In this way, if you have a second marriage with children from a first marriage or a previous life, you can protect the inheritance for all the children. So there are some downsides, of course, to having separate trusts. The first is that you've got to do what's called asset balancing. Now, when you have two trusts, or you create two trusts, the assets of the couple need to be split. So half of them go to one trust and half of them go to the other trust. This can be a problem when people don't have substantial assets. In many households, the main primary assets that exist are retirement account and the house. Now, the retirement accounts will stick with each individual. The house will need to go into one trust or the other trust. So if you don't have substantial assets, it can be kind of dicey on deciding who gets the house. On the other hand, if you've got like a house and a cabin and some investments, you can balance the assets. One person gets the house, the other person gets the cabin and certain investments to balance out the assets, then everything else is split evenly. You can't avoid this if you have separate trusts. The other thing with separate trusts is administration. I wouldn't say that this is very big, but it can cause some people second thoughts about having separate trusts. First of all, you have to continue the asset balancing throughout the lives of A and B. So you have to continually do asset balancing. If you gain a new property, then you've got to look at the trust again and shift assets back and forth. It can be kind of a pain. The second thing is when the first spouse dies and their trust becomes irrevocable, it actually remains to be an entity as in and of itself. It has to register with the IRS and it'll have to file a tax return every year. So instead of one tax return, you got two tax returns. Is that a problem? I don't know. I think you just gather the papers and send it to the CPA. Maybe you'll have to spend another hour of time, but some people don't like to deal with that, so don't want to deal with separate trusts. So let's look at joint trusts. So in joint trusts, obviously you've got A and B. We're going to switch the colors. They're married and they have one trust together. So when A dies, B maintains a revocable living trust, and when B dies, everything is distributed out as the joint trust says. Now, a benefit of this is administration. It's much easier. You don't have to do any asset balancing. You don't have to split the assets. When the first spouse dies, there's no second separate tax return. It's just easier, as long as you're a stable married couple, to maintain the joint account. Another benefit is you got shared control. If something happens to A and they become incapacitated, either with a coma or having dementia or something along those lines, B already has access to everything and can just manage all the assets as if they had a durable power of attorney in place. It's a very effective way to go. Everything's owned jointly. Another benefit is flexibility. After A dies, if they're separate trusts, the principal is locked off from B's access, except in extreme circumstances, which you can write into the trust, such as a major medical issue or something along those lines. And B only gets an income. B doesn't have access to the assets in A's trust. With a joint trust, after A dies, B still has access to all of the assets. So they have more flexibility to take care of anything that goes on in their life. I guess the final benefit is they're easier to manage after death. Because there's no irrevocable trust, there is no separate tax return that has to be filed. A downside of having a joint trust is that there's no creditor protection after the first spouse dies. Because there's no irrevocable trust to shield assets, and it's all owned in the revocable living trust of the surviving spouse, revocable living trusts don't give any asset protection at all. So if you have creditors coming after you, they're going to be able to go after those assets. Another downside is control. As you saw earlier, I won't draw it all out, but if they've got children from a first marriage or a previous life, there's no guarantee that all the children will receive the same benefits. A loses all control over how the beneficiaries are going to receive their inheritances. So a couple notes before we go on to the strategy and get some final thoughts in here, but a couple notes that are important to keep in mind. First is on remarriage. Now, I get a fair number of clients that come to me and have done a little bit of research, and they say, we are in a second marriage, therefore we need to have separate trusts. And my first question is, why? They say, well, we're in a second marriage. And but that's really not the reason. A second marriage is indicative of circumstances, but is not, it doesn't mandate that certain things happen. For instance, if you're in a second marriage and you've been married for 10 to 20 years, there's a much less likelihood of any divorce happening where you would have to keep an asset split would be of benefit. If, for instance, when you got married, there's children from a previous marriage, but both the children were 1 year old and both spouses raised the children as their own throughout their entire life, there's a very little chance that one of the spouses is going to disinherit the children from the other spouse because they've raised them as their own. If you're in a marriage that has been long-lasting and you have great relationships with all the children, you may not need to have separate trusts. Another thing to think about is estate taxes. Now, if you have a taxable estate, which in Minnesota is your estate as an individual is $3 million, or as a couple is $6 million, or on the federal level, if you have an estate in 2021 that is worth $11.7 million, or as a couple $23.4 million, then you need to start worrying about estate taxes. And to do that, the first defense that we have is called portability. Without going into a big explanation, it allows you to double the amount of exempted assets. Some people think you can only take advantage of portability if you have separate trusts. That's not true. You can take advantage of portability with a joint trust just the same as a separate trust. It's a little trickier to set up, but you can do it. So if you want to have joint trusts and you talk to your attorney and they say, well, you've got an estate that is taxable, so therefore you need to have separate trusts, talk to your attorney or find another attorney and someone that can take advantage of just doing the joint trust like you want and take advantage of portability. So the big question is, what is better for a couple? Is it a joint trust or is it a separate trust? Well, a separate trust might be more appropriate for people that are in a second marriage. If right when they get married, it might be better to set up for separate trusts, especially if you have children that are maybe even children that are adults. Separate trusts might be more advantageous for couples who own individual property prior to marriage, or for couples that are expecting to have an inheritance of a substantial size, especially if there's an inheritance of real estate. That might call for having separate trusts. And the other reason you might want to have separate trusts is if you have a prenuptial agreement. Sometimes the terms of the prenuptial agreement are easier to manage with separate trusts than they are to guarantee with joint trust. For joint trusts, they're going to be better or easier probably for first marriages, probably for marriages where people don't have kids yet. Couples who have the same beneficiaries in mind and the same distribution goals in mind are certainly going to be well served with a joint trust. And finally, couples that want to have the same trustees, that's kind of mandatory, because if you have a joint trust, you're going to have the same trustees. So if you don't have the same trustees in mind, co-trustees and successor trustees, then you might want to have separate trusts. So, in a nutshell, that's it. Joint versus separate trusts. I hope this video has been educational for you. If you liked it, please feel free to smash that like and subscribe button below. It really helps support the channel. If you subscribe, you'll get a new video every other week on Wednesday. And if you have any questions, please feel free to leave them in the comments below, and I'll try to make sure to get to them. So thank you. Until next time, this is Gregory Singleton with Signature Law.